That shocking development regarding the case of Detective Sergeant Kelly and the mobile phone recording of that incident in Buckfield, St. Anne in July 2010. Let's have more.
Yes, Buckfield has more on those developments as they unfolded in the Home Circuit Court today.
Ian Lloyd was reportedly suspected of fatally stabbing his common-law wife before he was shot dead by Sergeant Kelly. A video surfaced on social media showing him lying on his back while being beaten by a uniformed policeman. He was then circled by Kelly, who pointed his gun at him. Lloyd appeared to throw a small object in the direction of Kelly and was shot dead. Just before noon today, Justice Marva MacDonald Bishop upheld a no-case submission filed by Sergeant Kelly's lawyer, resulting in the policeman being freed of murder. The veteran defense attorney says the prosecution was not successful in admitting the controversial video into evidence. Mr. Neita says Kelly was acting in self-defense. Before video footage of the killing went viral on mainstream and social media, the police information arm, the Constabulary Communications Network, issued a statement saying Lloyd was shot dead after he attacked the police. After seeing the disturbing footage, Police Commissioner Owen Ellington immediately ordered the arrest of Sergeant Kelly and 2 other policemen. The Police Federation, known to be vocal in support of the police, also issued a statement describing the killing shown on video as, quote, barbaric and abominable, end of quote. Then chairman of the Federation, Sergeant Raymond Wilson, called for speedy action to deal with the policeman shown on video beating, then shooting Lloyd. Public Defender Earl Witter also described the killing as abominable, while various civil society groups also expressed shock and outrage. What the public might have thought to be an open and shut case for the prosecution has resulted in a not guilty verdict. The questions are many this afternoon for the Office of the Director of Public Prosecutions. Abka Fitz-Henley for Nationwide News.
Thank you, Abka. And to help us with those questions this afternoon, we have the Director of Public Prosecutions with us, Paula Llewellyn, and the lawyer who represented Detective Sergeant Lloyd Kelly, Churchill Neita. Good afternoon, ladies and gentlemen.
Good afternoon, gentlemen.
Good afternoon. Good afternoon. Well, let me begin, Madam DP, Mr. Neita. Mr. Neita, you did your job on behalf of your client. Congratulations. But for the rest of the country this evening, as Adka said, several questions, because this thing rocked the nation. It went viral, and tonight people are saying, what purpose is there where justice is concerned in this country when we are unable to get what seems to be an open and shut case right? Madam DPP, you're under the microscope this evening. Where did it go wrong?
Good afternoon again. We are always under the microscope. And remember, each case has to be looked at it on its own particular merits. Just recently, we got a prosecution of conviction in the Rashawn Hamilton matter. Police officer was convicted of murder. Recently, again, Jamaicans for Justice were concerned, and we issued a press release in respect of why we had to offer no evidence in respect of 2 police officers in the shooting death of Michael Scarlett. And this evening, the learned trial judge upheld a no-case submission. In this case, from the time that I did the ruling in the matter, we highlighted and we knew that there were going to be several challenges. I was looking back at my ruling and I made the point to the police that given the nature of the content of the statements, I had viewed the video footage on file. The statements were to a large part quite sympathetic to Sergeant Kelly. I was briefed by Crown Counsel a short while ago, and she said, Miss Llewellyn, they not only remain sympathetic, but at least one witness literally enlarged the stones that he said he saw. And none of them, Churchill, you can correct me if I'm wrong, but she briefed me and indicated that none of them actually saw any shooting per se of Mr. Lloyd. So what the Crown was left with is the imperative that they would have to get the video footage admitted into evidence. Now, unlike social media clips.
What about the post-mortem report, Madam DPP?
I'm sorry?
The post-mortem report.
Post-mortem report.
Yes.
Dr. Rao, the forensic.
Well, Dr. Rao was not present. Dr. Rao has migrated, and we tried to get in the post-mortem report under the Evidence Amendment Act, Section 31DC, but there are certain legal hurdles that we have to pass. We have made recommendations to the ministry.
Hold on, DPP. Hold on, DPP.
The post-mortem did not go in.
DPP, just a moment.
Yes.
What efforts were made to get Dr. Rao to give evidence here?
Well, first of all, I can tell you that we are facing, because of lack of resources, we have had to be using Section 31DC as best as possible, because the Ministry of National Security has indicated time and time again that given the volume of cases where the doctors who now reside in India, I assume that's where he's gone back to, there's just an issue of lack of resources.
What do you mean by that? What do you mean by that?
You can't afford to fly him back to Jamaica, DPP Llewellyn?
There is an issue in terms of lack of resources.
Yes, but be more specific. In this case, was Dr. Rao asked to be here, or was he asked to give video evidence?
No, we don't have the video evidence scenario in train as yet. So we couldn't use that.
So was he asked to come back to Jamaica to provide evidence?
Well, I did not get that briefing from Crown Counsel, but I do know that we have had to deal with quite a few cases. In fact, when I prosecuted the Good Samaritan murder case last year, I had to use the same section to get in the evidence of the doctor who was resident in India.
Dr. Rao has done several such post-mortem examinations and would have provided several, if not hundreds of reports. Are we therefore to say, are the people of Jamaica being told tonight that because of resources to fly Dr. Rao or whoever is the other forensic pathologists involved back to Jamaica, we can expect more such results as we had today?
That is not a fair way to put it, because we have the provision in the Evidence Act. So we have been able to get post-mortem reports in. We have been able to get them into evidence.
So
but it depends on the particular tribunal. It depends the judge you are before. And if the judge took the views that the Crown still fell short in respect of what we were trying to lay. Churchill, what did the judge indicate?
The judge ruled that the conditions in Section 31DC had not been fulfilled. And,
what are those conditions?
Circumstances that she omitted the.
What are those conditions that were not fulfilled, Mr. Neita?
It's laid out in the law, you know.
Yeah, well, tell us.
The efforts that have to be made and so on to establish that you have made reasonable efforts to locate him and to bring him back. And that was not done. That was not forthcoming in the evidence, you see.
So we now know, based on the learned QC, Madam DPP, your Crown Counsel, your office did not make reasonable efforts to get Dr. Rao here.
You know, I think, with the greatest of respect, Cliff, you know, there are legal requirements. We have done many cases, and sometimes judges differ. Sometimes I have had Crown Counsel tell me that they leave the same sort of whatever is there before one judge. That judge does not rule it in, and they do the same thing in another case before another judge.
In this instance, though, Madam DPP,
for the Good Samaritan case, and I got the post-mortem report.
Hold on, no, Madam DPP, in this instance, your office did not make those reasonable efforts to get Dr. Rao here.
Mr. Hughes.
Yes,
the office of the DPP does not control the budget of the Ministry of National Security. We can only, when we make requests.
Your job is to fulfill the conditions of the Evidence Act.
You have to understand exactly what the provisions are. And as a
to
matter
make
of
reasonable
practicality,
efforts to get him here,
but the
as
reasonable
according to
effort would
QC
hinge,
Neita.
Mr. Hughes, the reasonable effort must hinge on the budgetary resources of a ministry. We do not control that.
Therefore, the message to the people of Jamaica tonight is, therefore, the message to the people of Jamaica tonight, dog, name your supper, where justice is concerned, because we don't have the money to get the forensic pathologists here.
That could not be so, because we have done many cases. Churchill, haven't you seen several cases where we post-mortem in?
Yes, that is a
under
fact.
particular
Yes.
circumstances.
I can see that independent circumstances.
Also, Mr. Hughes, the particular video footage could not be admitted into evidence.
Yes.
Hold on. Let's take the break and come back with the video footage, because that's the other area to look at. Let's take a break and come right back, please. Welcome back. We're speaking with the DPP, Paula Llewellyn, and the attorney who represented Detective Sergeant Lloyd Kelly, Churchill Neita. Cliff, are you there?
Yes, I'm here, George.
Good. DPP, before the break, we were looking at the issue of what efforts were made to secure that amateur surveillance video of the incident.
The matter is that we, from the time we did the ruling, we indicated that the Crown, based on the authorities on these issues, the Crown must establish the provenance and the authenticity of the video footage. In the media world, you can just show it, but as a matter of law, unless we can establish the provenance and authenticity from the person, the maker, it will not be admitted in evidence.
Yes.
And you could not find the maker.
Also, the Crown has to negatize.
Well, tell us what did you do to establish that, DPP?
The fact of the matter is that the investigators, the police investigators from BSI, they were in search of this particular individual. And let me tell you something, gentlemen, and let me tell Jamaica, the prosecution of a case is only as good as the material that you have available. And it's people who know that they have evidence available do not come forward. We cannot make blood out of stone. We did the Rashawn Hamilton matter. We had witnesses who cooperated. In this matter, it was quite clear from day one. We must get the maker of that video footage. As a matter of law, the authorities
and the police were not able to find him, DPP.
Well, he didn't seem to have made himself known. That was my information.
So they didn't know who to look for. So they didn't know who to look for, did they?
Well, I don't really know. Churchill, can you shed light on that? Did it come out at all in the evidence?
What?
The efforts to locate the person who shot the video footage.
No evidence at all was led about the presence or where the video was. Nobody knew.
But Mr. Neita, in working on this case, Mr. Neita, here you had a situation where a man was dead, who was a menace to the community. Nobody, even on the day that he was killed, the people were saying good riddance. Yes?
Yeah.
And you knew the difficulty that the prosecution may have had in getting witnesses and getting their hands on that video. The maker of the video. So
the maker of the video, yeah.
Wasn't it then a simple thing for you to go with a self-defense, a point of attack, and ask for a no-case submission, knowing very well that nobody would cooperate with the prosecution?
No, well, I would make a no-case of submission as I did based on the evidence.
Yes.
And as the DPP rightly pointed out, there was a challenge for the prosecution because the witnesses spoke of what is called classic self-defense.
Yes.
The witnesses spoke of an attack on the police who were trying to restrain him and an attack on the accused himself. By a bottle that was broken that he was holding and cutting at the people, the police officers, in a menacing manner, and also throwing stones. The point that Paula has made is what I want to emphasize. That we have to understand that
Hold on, QC. You need to go further. Yeah, that may very well be so. But the video that we saw also showed where he was virtually prostrate, not being a menace at the time he was fired on.
Yes, but Mr. Hughes,
But that is
Yes,
not
Madam
I saw the video. The video
evidence
shows
that comes from the mouth
when
of the mouth of the witnesses that the court has to consider.
their evidence.
And that is what it is.
Totally different color on it.
It's an
as
entirely
Michael
different
Frost
thing.
said. One witness literally, when he gave evidence, he enlarged the size of the stone.
But DPP, you can understand then why we are upset at the fact that heaven and earth wasn't moved to get Dr. Rao here.
But Dr. Rao would not have made any difference because you still would have had the evidence of self-defense on the Crown's case.
But
the Crown has
That
to
is a fact.
discharge the burden of negativing self-defense.
but how?
You have witnesses who are going to come and indicate that large stones
All right.
and bottles are being rained
But let me take you there,
in
DPP.
different places on the accused. Then you are going to have self-defense being totally lied.
But how much different would it be to self-defense if the post-mortem report could show that this man was lying on his back when he was shot? How much of a menace could he be to the policeman lying on his back and being shot at very close range?
No,
is not going to show that because
With all due respect, the post-mortem could not establish that.
the
Post-mortem could only establish the cause of death.
the cause of
You
death.
understand? That is all the post-mortem could do. That
Remember,
a
as a
bullet was
matter of
taken
law.
from the abdomen of the deceased, and that is what caused the injury. They can't speak about positions or
They
anything.
can't speak about position. It is only the witnesses who were present.
Only the eyewitnesses who could say that.
And the eyewitnesses. In fact, I understand from my concounsel that by the time the eyewitnesses finished their evidence,
Yes.
this man was not seen throwing one item,
Yes.
as you saw in the video.
Yes.
But he was quite strong in throwing at the accused on 3 different occasions.
It is every yes.
Missiles and huge stones.
And that when he was shot, he had the broken bottle in his hand. That
what
is
the
the evidence
eyewitness
that emerged, yes.
Cliff?
What
And the video, didn't show that though, QC.
But I don't know about the video. I'm talking about the evidence.
Yes.
Understand, as the director says, that is the only thing that the court can consider.
Yes.
Precisely.
Because
What is
the
before
judge
her?
made a ruling on the evidence, and I would like to make the point that she's a judge of extreme competence, erudition, and
agree with that.
capability.
She's an excellent,
That cannot be there.
you know.
It's
We
not
have
about the
to
judge
balance
here.
and fairness,
We have
and what
raised
she
no
has to
issue
do,
about
she
the
has
judge.
a tremendous knowledge of the law.
No, we
And-
haven't raised an issue about the judge at all.
No, but I'm
What
only
we're
telling you.
concerned
Based on the
about.
evidence.
I'm only telling you that the evidence,
Yes.
in the circumstances, the judge was obliged to
She had to.
accede
And it
to
is
the
based on
request,
the
to
evidence.
the application.
Before we go, I want to raise with the DPP to revisit the issue of what now for the hundreds of post-mortem reports done by Dr. Rao
Nothing but
and the fact that
I'm
he's not
concerned.
here. Are we just going to say, okay, we don't have no resources, so we're
But
going to leave it at
Mr.
that?
Hughes, what I'm trying to say, the Evidence Act provides for us laying the necessary foundation
Yes.
to prove that it's not reasonably practicable and that he is not able to return and it's not reasonably practicable. The Evidence Act provides that. We have made recommendations to the Minister of Justice that the time has come that consent, these post-mortem reports should be able to go in through by consent
Yes.
of both defense and prosecutor. But until such time, we still have to rely on what is basically cumbersome.
Yes.
Would you say so, Churchill? Very cumbersome.
Yes.
Mr. Neita, was it difficult for you to get civilian witnesses to support your case?
Not at
Was it
all.
difficult?
Not at
Yes.
all.
No, what I never needed witnesses to support my case because the prosecution spoke with the same voice as the defense. As I said, it was a case where there was flagrant self-defense, so I never needed to get witnesses.
Because the prosecution witnesses, George,
Because the prosecution witnesses were
provided a case of self-defense. for the
self-defense,
accused. The
and that is a fact.
prosecution has a burden
Yes.
prove or negative self-defense on its
Yeah.
own case. So if your
The prosecution couldn't do that.
if your witnesses come and say that this man was almost hurling all these missiles,
Yes.
it hit him in the groin, it hit him in the chest, it hit him 3 times, and he warned the deceased. And
Yes,
he fired.
and the evidence was that the police
Self-defense
officer The evidence was that the police officer told him to drop the bottle, and he said, I'm going to kill somebody else today. You understand?
Yes.
The police officer instructed another police officer to try and put handcuffs on him, and they couldn't do so. They had to back off because they were being caught at the man who raised up from time to time with the bottles in his hand. The evidence was that after the baton hit him on his hand, one of the police officers, and the bottle fell, he picked it up and continued. And that he threw a number of stones, one of which actually damaged the police vehicle, and that he threw stones even at the citizens who were there. That is the evidence that emerged in the case, and it's on that basis that we were able to submit, and the judge quite properly acceded to the no case submission.
So the argument tonight, it's not about the DPP, it's about us Jamaicans, because we saw what happened, yet the persons who were there saying they were eyewitnesses went into court and told a different tale to what we saw in court, and the DPP couldn't go off the video because she couldn't authenticate who made it.
And the post-mortem result was unknown.
And the post-mortem result was not in court. It's amazing. Yeah?
People have to understand.
Jamaica.
We are gone as a country. Yeah?
Come forward. You know there are
But that's rather harsh, with all due respect.
Mr. Neita.
You have to work with the material. Listen, I want to tell you something.
Yes.
That this young council made a very valiant effort to prosecute this case. And I want to commend her for that. I did so after the case.
Miss Sims worked against very good odds, strong odds.
I instructed her and I said to her, listen, you have to pay the cards that you get. That is how the system is. You cannot make blood out of stone. And even the judge
Thank you, Mr.
said to
Neita.
her, it is not your fault, Miss Sims. You did the best that you could.
Yes.
Mr.
You
Neita,
don't
we've
have
got
the
to go.
material. That is the horse that you get to ride. You have to ride it.
Thank you.
Thank you.
Thank you.
Thank you very much.
Churchill.
Thank you. Cliff?
Madam DPP.
Boy, you see, the DPP didn't fail justice, Jamaica's people failed justice. But that's another thing for another time.